This video was made by special request of the Indiana State Police.
We'll hear arguments first this morning in Tennessee against Garner and the consolidated case. Mr. Klein.
Hi, my name is Conrad, and welcome to SCOTUS Simplified. Today, we will be looking at the landmark Supreme Court case, Tennessee v. Garner. The facts of the case. On October 3rd, 1974, Edward Garner had climbed onto a trash can, broke a window, and gained entrance to a Memphis home. Two police officers, Leslie Wright and Elton Hyman, were dispatched to check on the situation. Upon arriving on the scene, Hyman made his way around to the back of the house and saw the broken window. Hyman then saw Garner leaving the house and gave the command, "Halt! Police!" All of this was taking place at about 11:45 p.m. When given the command to halt, Garner turned around and Hyman shined his flashlight onto his face. Garner then attempted to vault a 6-foot-high fence. Due to clutter in the yard, Hyman assessed that if Garner made it over the fence, he would get away. Hyman then made the decision to pull his weapon and fired a single shot at Garner. The shot hit Garner in the back of the head and he died shortly after getting to a hospital. Hyman was acting in accordance with a Tennessee statute that authorized use of deadly force to prevent the escape of a felon. And in Tennessee, at that time, burglary was a felony under their laws. Garner's father sued, naming the city of Memphis, its mayor, the Memphis Police Department, its director, and Officer Hyman as defendants. Garner's father cited the Third Enforcement Act of 1871, which protects those who have had their constitutional rights taken away from them in one way or another. Ultimately, the question posed to the Supreme Court was that of the constitutionality of using deadly force against someone, and if it was in violation of the Fourth Amendment. This case has since laid the groundwork for the Fourth Amendment to be used as the standard in assessing most police force cases, specifically the application of the Fourth Amendment as a way to look at deadly force. The right of the people to be secure in their persons, against unreasonable searches and seizures, is what is assessed in this case and others when it comes to deadly force, as it is a seizure of a person's life. This case was argued on October 30th, 1984, and a decision was reached on March 27th, 1985. So, who are the players in this case? For the petitioners, Henry L. Klein. This is Mr. Klein's first time in front of the Supreme Court, though he would go on to fight in Brandon v. Holt later that same year. For Tennessee, Attorney General W.J. Michael Cody. This is Mr. Cody's first time in front of the Supreme Court. For Garner, Stephen L. Winter. This is Mr. Winter's first time in front of the Supreme Court. Now that we understand the facts leading into this case, we can dive into the arguments posed to the court. Mr. Klein primes the whole session by listing the points he wants to make to the court. Specifically, Mr. Klein will be looking at the constitutionality of the Tennessee statute that authorizes a police officer to use deadly force to apprehend a fleeing suspect.
The first deals with the constitutionality of the state statute with regard to the use by a police officer of all necessary means to effect an arrest. The second is whether the municipality's use of deadly force to apprehend a fleeing burglary suspect after exhausting all other reasonable means is constitutionally permissible.
Mr. Klein also addresses the ability of the responding officer to have to make quick decisions while also considering the ramifications of their actions.
Because of the standards set out in the Model Penal Code, it requires a police officer to make an on-the-spot constitutional analysis and still react to the exigencies of an emergency situation.
Mr. Klein goes on to talk about what would have happened if Garner had given up on the spot.
Now, in this particular situation, when the police officer arrived on the scene, all the individual had to do when confronted by the officer and told to stop was to do so. And that would have been an end to the situation.
Police officers must make split-second decisions, and more often than not don't want to put their lives in unnecessary danger. Klein touches on this.
It may involve, for example, in the case here, The officer, when he arrived on the scene, didn't know what was going on inside. There may have been some victims laying on the floor.
Klein then tries arguing that pulling a deadly weapon is a way of apprehending suspects. Stevens thinks very differently, in that you pull a weapon with the intent to kill.
And it also means, I take it, that he may deliberately shoot to kill.
Well, when you say deliberately, Your Honor, yes,
doesn't it mean that? I'm just trying to understand.
Right. Yes, when he pulls his weapon, that's what he's intending to do.
So it's really more than apprehending him then.
No.
We now move to Attorney General W.J. Michael Cody, who continues the arguments for Tennessee. He starts off by addressing what the result of limiting police powers would do.
And the rule which would allow a fleeing felon to disregard the fact and to say that the police have no threat or no ability to use maximum force if necessary will encourage in property crimes or burglary crimes, as we have here, will encourage the criminal to run each time. If there is.
Justice Blackmun addresses the fact that in other states, the idea of having officers consider the ramifications of their actions has been working.
So I was curious.
Well, I have no information, but I believe that it would be unworkable if the officer is put to the task of trying to make this probable cause analysis when he arrives at an arrest scene.
Well, certainly the fact that other states have a different rule would indicate that it works.
We now move to Garner's defense, led by Winter. Winter starts with a very compelling study that shows that officer safety goes up when a municipality has a restrictive deadly force policy, while arrest rates and crime rates stay the same.
Investigated, I would point the court to the amicus brief filed by the various police organizations and over 30 individual police departments in this country from common law and non-common law states alike in support of our position in this court. And they recount the studies that have been done in these jurisdictions. Arrest rates do not go down. Crime rates do not go up. The only thing that is affected by a more restrictive deadly force policy is the rate of officer safety, and the rate of officer safety improves under these more restrictive policies.
Winter and Rehnquist then have a small back and forth about the officer's ability to use deadly force.
If in fact the person is armed but he never reaches for his weapon, I don't see where the state interest in shooting to apprehend or to stop prevent escape.
Armed and be not reaching for his weapon 1 minute and 15 seconds later he can be reaching.
And when he reaches, I think the officer is obviously entitled and should shoot.
Not until then.
Not until
I
then.
suppose if you have
A situation such as this brings the outcome down to a simple who can draw first challenge, which no officer should have to be forced into. Finally, Stephen brings up the matter of the race of Hyman and Garner.
Factual matter. Does the record tell us the race of the victim and the race of the officer in this case?
In this case, yes. Both were black.
Both were black.
On March 27, 1985, the court decided in a 6-3 vote in favor of Garner. The court found that the Tennessee statute in question was in violation of the Fourth Amendment, as it allowed for the use of deadly force against an unarmed suspect, and that this fell under unreasonable seizures. So, what do you think? The question of how much force police should use has been a topic of discussion for both modern police and police of the past. Hyman was acting in accordance with the Tennessee statute at the time, which allowed for such force to be used against a fleeing suspect. At the same time, Hyman suspected that Garner was unarmed, though he did ignore police orders. This is the first of 2 landmark cases on police force. The second case in this series that we will be looking at is Graham versus Connor.